starting now. Today is the 165th Friday group meeting. Our speaker is beloved advocate Shobha Gupta ji. Earlier also she addressed our Friday group. Today's topic is dichotomy between age of consent in POCSO and personal laws on marriage, varying views of court and the confusion around. So this is the topic. Earlier on 135th Friday group meeting she addressed, that is on 6/12/2019. The topic was rape and murder and speedy justice challenges before Indian judiciary and society. That's a very serious problem that time. Thank you, Shobha ji. We are grateful to you. So instead of wasting our time in this thing, and I'll request Thakur will read Shobha's CV. You take it. You take this one.
Please, sir.
Yeah.
This is the mic.
Yeah.
Good afternoon, ma'am. Shobha Gupta. So, madam joined this profession in Rajasthan High Court bench, Jaipur, in 1995. Thereafter, she joined Supreme Court in 1997. Madam worked in many fields like PILs, constitutional cases, civil dispute, rent and eviction cases, criminal matters, service law matters, labor cases, company law cases, consumer disputes, educational matters, mines and matters, so many matters, including corruption matters, motor vehicle acts, etc. Madam is also a standing counsel of National Human Rights Commission for last more than 16 years. Panel lawyers of other government, semi-government and private organizations, including that of Educational Constitutional India Limited. Madam is also founder of Flag Free Legal Aid Group for imparting free legal aid to juvenile detained on being found on the wrong side of the law. Recently founded a social platform in the name of We the Women of India to create awareness in the society at large about human rights of women and to create equal and respectful space for women and to help the women in India in need. Thank you, ma'am. Now you can just keep it.
You have to keep it. Otherwise difficult for 40 minutes. She knows there's some problem with this, so
Let me just rebut it. Then you correct it, huh?
yeah. Good.
Is it okay?
Okay.
No?
Better. 40 minutes. Roll which is good.
क्या करना है?
Yeah, now you can start. Now you can start.
Good afternoon, friends. This process of introduction makes it so formal exercise. Huh? Otherwise, we all can discuss. And honestly, I'm not going to do this as a lecture to give gyan. I'll open the topic. I find this topic very serious because of maybe for last 2-3 years precisely. We are getting judgments from various high courts, and every time they came out with some new concept of it or maybe contrary views. So if we lawyers are getting confused with what is the law of land and whether the sexual relationship between a minor and the other person is adult is punishable or not, whether the defense of consent is available at all to the accused, and how it has to be seen from the spectrum of the mandate of the POCSO Act. So this was troubling me as a lawyer a lot, and I thought why not discuss it out amongst us. So I'll open the chapter, I'll open the topic, and then we will discuss it. It is not as if I am going to shower some knowledge. I'll discuss whatever is available to me out of my research, which is still not very exhausted. And then I would be discussing all of you who can, requesting all of you who can just, have a debate, an open debate, so that at the end of the day we all are enlightened to whatever extent we can. I was just wondering, when it comes to, even recently when Justice Banerjee retired, and she had also opened the debate, and she said there has to be a relook required about the age of consent by a minor for establishing a sexual relationship. Certainly then she is referring to a relationship which is consensual by both the parties. But we also know in by and large, invariably, I believe in each and every single rape case also, the first defense comes is of consensual act. Some which way they assign a consent to it, because in all the acts of sexual violation of a woman, it is very difficult to have witnesses around. This is one crime or one act where most of the time it is happening in a closed area, in a dark area, not witnesses are available much. Therefore, any defense which we allow in this area may open a Pandora box, can be very, very critical area of concern for the system. Can this be available easily as a mandate or maybe as a sanction, judicial sanction, be in terms of the court orders or be in terms of some amendment in the statute itself? I'll put across before all of you my thought process, that why I am finding it this way, why I am feeling that no, it may not be very safe. And then let's discuss it how it goes. So when I was thinking that can consent be attached for a decision to a minor, can we attach a consent, so to say, a minor is capable, legally capable to take a decision where a voluntary act is also can be assigned to it. My understanding of reading of law and whatever provisions we can go through, I might be falling short of my research, so please add on, that a minor has no legal capacity to consent, to take decision for himself or herself. These limitations are coming to fore from various provisions of law, which include, and I'll keep referring to various sections just for your notice, and then we'll proceed further with the legal aspect of it. So, who is minor? What are these acts and provisions which deal with the age of minority, and are there many variations as far as our country is concerned? We can reflect to the international aspect a little later. Majority Act, which was earlier Indian Majority Act, an amendment came. So it is Majority Act 1875. Indian term has been removed from the nomenclature of the Act later. So now it is read as Majority Act 1875. Section 3 of the Act defines minor as age of majority of the person domiciled in India as under age of majority of persons domiciled in India. It says every person domiciled in India shall attain the age of majority on his completing the age of 18 years and not before. This is how they have defined majority. We have coined the term minor later. It also says in completing the age of any person, the day on which he has born is to be included as a whole day, and he shall be deemed to have attained majority at the beginning of the 18th anniversary of that day. So if 1st of January 1910 is the date of birth, so 1st of January would be included while counting the age. This is what the Majority Act says. Now, Indian Contract Act. Can I enter into a contract? So consent would also be a contract. In any relationship, the moment I agree for an act, I am contracting for that act in legal terms. Contract Act says, section 11, who are competent to contract? Every person is competent to contract who is at the age of majority according to the law which is subject to Majority Act. So again 18, Hindu Marriage Act 1955. It says, section 5, a marriage can be solemnized between any two Hindus if the following conditions are fulfilled. I am not referring to the other conditions since we are concentrating on age. The bridegroom has completed the age of 21 and the bride has completed the age of 18 years. So, consensual or maybe a legal relationship which can end up in a physical intercourse is something which has dealt with in this particular act, which is not by and large secular. This is qua Hindus, which excludes Muslims, Christians, Parsis, etc. Now, Prohibition of Child Marriage Act. This is a 2006 act. It defines child. It doesn't deal with term minor or major. It defines the term child. It says a person who, if a male has not completed the age of 21 years, if female not completed the age of 18 years. Child marriage is then defined, so to say, as a marriage to which either of the contracting parties is a child. So two of them, if one of them is child, is again a child marriage which is prohibited under the Child Marriage Act. It says further that it is voidable on the instance of any of the contracting party, but after they attain majority, or otherwise through their guardian during the period of minority. It also further says section 9, and this is important for the purpose of POCSO, punishment for male adult marrying a child. Whoever being a male adult above 18 years of age contracts a child marriage shall be punishable with rigorous imprisonment which may extend to 2 years, or with fine which may extend to 1 lakh rupees, or with both. So if we say, I'm not entering into that area, moral area at all, but if we say marriage is, the opening gate and one can enter into all kind of relationship between two of the genders, here also it says if one of the person is child, then it is a punishable offense if a challenge is raised to it. It further says section 12, marriage of a minor child to be void in certain circumstances where a child being a minor is taken or enticed, and this is forced. The child is either enticed, allured, or some which way taken to marriage, and the marriage has taken place. Consent is not involved. Then again it is an offence. Now comes the Guardians and Wards Act. So I am just dealing with all the acts where they were dealing with minors and how the interest of a minor is to be protected. And we have to keep reminding us that we are signatory to the United Nations Conventions, where we have promised that we would be enacting all laws for the keeping the best interest of the child in consideration. So Guardians and Wards Act says minor means a person who, under the provisions of the Indian Majority Act, is to be deemed not to have attained his majority. Again we go to the first one, that is 18 years, because Majority Act says 18 years. Guardian means a person, and that is interesting, I just took this one also for the purpose. Guardian means a person having the care of the person of a minor or his property, or both his person and property, but he himself cannot be a minor. So a person can be guardian to protect what? To protect the body of the minor, to protect the property of the minor. But the person is then required to be a major. Major means has to be above 18 years of age. And then Guardian and Wards Act, you all are aware that we go to court, we seek for a guardianship for the protection of property and person of the minor till the person attains the age of majority, and the court then appoints a guardian for the purpose of protection and taking care of the property and person of the minor till the minor attains the age of majority. Then comes the Hindu Minority and Guardianship Act. Minor means a person who has not completed the age of 18. Guardian means a person having the care of the person of a minor, of his property or both his person and property. Incapacity of a minor to act as a guardian of the property, which is I just referred to under Wards Act also. A minor shall be incompetent to act as guardian of the property of any minor. I am reading here in property the person also. So I am reading person and property both. Now 13 is, we all are aware, like that's a Bible for us, welfare of a minor to be the paramount consideration. We keep saying this in all custody matters. And then overriding effect, where says this particular act override all customary law and other things when it comes to, since this is applicable upon Hindus, so they are dealing with Hindus. Hindu and exclusion is only Muslim, Parsis and Christians. Then Hindu Adoption and Maintenance Act 1956. Minor means a person who has not completed his age of 18 years, his or her age of 18 years. So again the cap is of 18 years. We have yet not touched anywhere 16 years or a variation of age, except Hindu Marriage Act, where for the bridegroom it was 21 years. Application I am leaving. Then comes the Juvenile Justice Act. Now Juvenile Justice Act, and kindly keep in consideration when we are discussing this, the purpose of Juvenile Justice Act and the purpose of POCSO Act. Both are dealing primarily with children. Both defines child as a person under the age of 18. The Juvenile Justice Act and the POCSO Act in their preamble specifically refers to Article 15, Article 39E and other. So to say, the country or the legislation has to enact laws to protect the children or to ensure their welfare, and then our signature to the United Nations Conventions. Section 2, clause 12 defines child under the Juvenile Act. I am referring 15, not the earlier one, because it has been amended now. Child means a person who has not completed 18 years of age. Juvenile means a child below the age of 18. Then it has principles of presumption of innocence. Now, this Juvenile Act is governed by a whole gamut of principles to be applied while considering crime by a juvenile. Right? A juvenile found on the wrong side of law. But while even looking at the crime committed by the juvenile, we have to follow these principles. I'm just mentioning the principles because I'm trying to reach somewhere qua the POCSO Act by referring these also for the purpose of addressing the confusion. It says principle of presumption of innocence. Any child shall be presumed to be an innocent of any malafide or criminal intent up to the age of 18 years. So you are not assigning any intentions for a child committing any criminal act. Principle of participation, every child should have right to be heard. Principle of best interest, we have just discussed. Positive measures, all resources has to be mobilized, including those of family, community, promoting the well-being, facilitating development of identity and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act. Principle of non-stigmatizing semantics. Adversarial or accusatory words are not to be used in the processes pertaining to a child, and therefore we call them delinquent. Children found on the wrong side of law, we don't call them accused. We don't call them criminals. We don't try them in criminal courts. Principle of non-waiver of rights. No waiver of any right of a child is permissible or valid, whether sought by the child, and this I would really wish to read in POCSO Act. This is missing in POCSO Act, but we must read this one in POCSO Act. Principle of non-waiver of rights. No waiver of any right of a child is permissible or valid, whether sought by the child or person acting on the behalf of child or a board or a committee, and any non-exercise of a fundamental right shall not amount to waiver. So you would not be waiving a right of a child, which includes a right of a child. Now I leave it for open discussion, this particular aspect, for consent or no consent under POCSO. Then comes principle of equality and non-discrimination. When we are reading this, kindly keep in mind that under POCSO, you have two genders involved and right of two genders involved. There shall be no discrimination. I am referring to when there is a case of two genders only. We are not otherwise referring to other instances. There shall be no discrimination against a child on any grounds, including sex, caste, ethnicity, place of birth, disability, and equality of access, opportunity, and treatment shall be provided to every child. And then the last one, I'm skipping so many out of it. This is a lengthy list of presumptions or the principles we followed. Principle of fresh start. All past records of any child under the juvenile justice system should be erased except in special circumstances. So how we are proceeding under Juvenile Act, that he or she is a child, committed a crime, we are assigning an innocence and immaturity of the mind not to understand or be capable of understanding that this is a crime which I should not have committed. And therefore, you deal the child with a reformative measure approach. You don't punish the child, you don't send the child to a jail, you don't treat the child, try the child in a trial court, in a criminal court. The board is supposed to sit, the members of the board supposed to sit not in uniform. The police persons are not supposed to be in uniform while carrying the child. You don't use the term arrested. The law says they have been apprehended, brought to police, to be taken to board, not to jail. Right? The record not to be maintained. Name not to be shown. Here you can read section 228A of IPC along with it. But otherwise the act also says that you are not supposed to disclose the name. Not to be reported, no reporting with the name and identity of the child. So you are, as a legislation, keeping the best interest of the child in mind, and keeping that concept that he or she had no understanding, no matured application of mind of what he or she has done, which under law is a crime. This is the approach under the Juvenile Justice Act. Now comes with this, and with this amendment, after Nirbhaya case, a writ petition was filed by 14 women lawyers in Supreme Court, and I was the advocate on record, and that was a brainchild of mine only, when we were challenging about the age to be determined, what documents and others, because in Nirbhaya's case, the particular juvenile had some interpolations on his record, which was noted by the judgment, but because of the requirements of the act, it said that we would go by what the final document brought to us, and therefore he was considered as a juvenile. But after filing of the petition, the government came and government said, central government, and they said we are amending the act. Amendment came. We got section 15, 16, which now creates a bracket of 2 years, 16 to 18. So to say, if the juvenile who has found falling on the wrong side of law has committed a heinous crime, they have defined heinous crime also, which includes murder, rape, gang rape, and all other crimes which are more than 3 years and serious in nature, then his mental growth has to be checked by the magistrate concerned. After having that preliminary inquiry, the magistrate of the board can decide whether this child has to be sent for a regular trial as a regular criminal in the criminal courts, or he or she still have to be tried before the board under this protective environment. But this is not something, saying if you are within 16 to 18, we understand you have a very good mental growth and you must be sent to jail or to be sent to a regular criminal courts or that environment. Still a test has to be applied. So till 2015 we have this growth when it comes to the legal aspect or in the form of legislations, that the legislators are recognizing the concept of variation, possibility of the growth in various, you have different variations in the growth of mind of children between the age bracket of 6 to 18. They would still get the benefit of the age if they are not 16, but committed a heinous crime. So below the age of 16, no exceptions. But for a bracket of 16 to 18, certainly they can be tested, their growth can be tested, and they can be then tried in a regular criminal court. With this, if we now examine the POCSO Act, so this is broadly the legal framework we have around. What is the age of minority, majority, and how the criminal aspect or consent has to be tested. Now, in this POCSO Act, again preamble says that we are signatory to the United Nations Conventions. We have to see the best interest of the child, and we have to see that the child is protected and the most protected environment is provided. Also consider, while we are considering POCSO, that the accused there can be of any age bracket. We may have, certainly we are dealing with POCSO, so certainly the victim is under 18. We need not to reflect much on that. So we are dealing with situations where your victim is certainly under the age of 18. As per majority, it certainly is minor. But the accused is either minor or major, may also be. the age differences between the minor and the accused. Just keep all that in mind and then I'll discuss it further. It can be a case when your accused is 70 years and the victim is 17 years. It can be a case when both are 16. It can be a case when she is 16 but he is 22 or 20. It can be a case both are studying in the same class, or it can be a case when they are studying in the same school but different grades. Should all that matter? Should we reach to a situation where we are examining the law on the basis of each of these nuances or all these possibilities? Or no, it should be a very straitjacket formula. Just fit in the facts in that formula and hence comes the answer. This is possibly the confusion and the solution we are talking in today's debate or session. Before reaching to POCSO, I'll just refer to 3 more provisions also. So under CPC, Code of Civil Procedure, it says no minor can file a suit. Suit can be filed only by a guardian who has to be major. Now guardian can be natural guardian can be a guardian appointed by a court under the Wards Act, or it can be any relative because of the relationship, blood relationship. But then we have a legal position where the minor does not have a legal permission to exercise mind and to reach court, so to say, oh, this is my property, not yours. Or this belongs to me, not you. The Limitation Act. Limitation Act further says, till you attain the age of majority, sorry, you are not permitted to come to court for yourself. You yourself. Somebody else can come. You can come through a guardian who we understand has a better, understanding, and we legally allow to apply a mind to have a decision-making process or to have the capacity to have a decision-making. Criminal Procedure Code. Again, it defines the manner as a person who, under the provisions of Indian Majority Act, is deemed to have attained the age of 18. Section 125 also entitles a minor a right to be maintained by his or her guardian. So various provisions of law, you are cementing this concept that you are a minor, you can't earn, you don't have a capacity to take a decision, you have to be protected, you have to be guarded, and there has to be a guardian who would be taking care of your interest. Then comes IPC. We have whole lot of provisions which deals with crime against minor. I am just referring to you, all are learned, so everybody knows, I need not to detail it. But it says female under the age of 18 years and a male under the age of 16 years has to be considered as minor for the purpose of sections 361, that is kidnapping. Then 363A, which is kidnapping or maiming a minor for the purpose of begging, again says a person under the age of 16 years if male and 18 years if female, considered as minor. 366A, procuration of minor girl, says that whoever by any means whatsoever induces any minor girl under the age of 18 years to do ABCD, which includes to go to place, to intend with such girl knowingly that she may be seduced or forced to illicit intercourse or to enter into any kind of relationship, is punishable to 10 years and fine. 372, 373, selling or buying. Like 72 deals with selling and 73 deals with buying. 372, 373, selling or buying for the purpose of prostitution. It refers to minor. Takes 18 years as a cap to define minor irrespective of their gender. 370, 370A, dealing with trafficking of minor and sexual exploitation of trafficked minor. It does not define age of the minor, but since we have seen all the sections which are attached to or connected to it, we would say that it should also be 18 in this case also. Succession Act again defines minor as under the Majority Act. So 18 years. 244, 245 of the Succession Act only requires administration of the property of a minor who is not attained the age of 18 years. Limitation Act, I have referred that there is a legal disability created under Section 6, read with Article 60 of Schedule, that a minor cannot institute till attains the age of majority. I'll refer the age of consent little later, but before referring to that, I'll come to POCSO first. POCSO, you have various provisions which deals with who is minor or child. Can a minor give consent? The provisions of presumption of culpability against the accused in case the victim is a minor. So I'll just refer that in a very fast-paced mode, and then we'll come back to the age of consent aspect. It says, we have section 3, 5, 7, 9, 11 dealing with sexual assault, that penetration, aggravated penetration, aggravated sexual assault, everything, right? And various penal aspects of it, punishments and all. We are not getting into this. Section 29 says, it defines the child as the age of 18 years, not attained the age of 18 years, so same age bracket. Section 29 says, there is presumption of criminal culpability qua the offences committed under section 3, 5, 7 and 9, not 11. 11 is sexual assault. But for penetration, aggravated penetration, sexual intercourse, for all these things they have a presumption of criminal culpability. That is your criminal mental state of mind when you are doing that act. So you cannot claim innocence qua your act by assigning certainly consent, because criminal culpability has already presumed against you under the law, unless certainly proven against by you. So this is an act which is a different approach than the regular criminal approach, that is, a person has to be treated innocent till proven guilty. Here the accused has to be treated guilty because of section 29 read with 30 till proven innocent. 30 is general, it is not particular offense centric, it is not qua 3, 5, 7 and 9, but it says your intention, your knowledge, your criminal culpability, all would be presumed against you unless you prove it otherwise. So certainly because of section 29 and 30 and subject to Indian Majority Act and Limitation Act also, CPC also, where it clearly says that you minor does not have the legal capacity to give a consent. With the presumption of 29 and 30, so to say, there is a presumption against you as an accused. So the moment you as an accused enter into any kind of these act or relationship, act, not relationship, I'm sorry, act, then it is a criminal culpability assigned against you. Prove it otherwise if you want to be proven innocent. On face of all this, now see, I'll refer again the age of consent in various countries little later, not now. But now see how the judgments have approached. So you have a Supreme Court judgment of 2017 where Justice Lokur and Justice Shobha Gupta, they said that sexual intercourse by a man with his wife who is below 18 years of age is rape. So you have already law settled qua this. There was marriage. POCSO is irrespective of marriage or no marriage. There they were dealing with a case where they were in a relationship of marriage, but court said no, sorry, with a girl below the age of 18 you cannot enter into a sexual relationship and it would amount to rape. Now see, the recently what all is happening is suddenly all the courts, I do not know why it is happening, I'll just add one more section of POCSO, section 34, which says if the offence under the act is committed by a child, then such child shall be dealt with under the provisions of the Juvenile Justice Act. So if victim and child both are minor, victim minor would be dealt with under POCSO the victim, the minor accused would be dealt with as juvenile under the Juvenile Justice Act, so he would get those protections, those benefits. Recent judgments which have coming in for, very much talked about, possibly almost celebrated, and you referred in your message also by one of the senior counsel, is Madras High Court recent judgment, where it says that I am sitting in an appellate jurisdiction. There was a case of conviction in a POCSO case of an accused who was certainly major. The victim was minor. The suggestion by the counsel for the defense was that this is consensual relationship. There is no piece of evidence, so to say, that she objected to it, and therefore he should be given benefit as other high courts are giving. This particular learned judge said that I cannot traverse beyond the statute. A statute does not allow a consent by a minor, and therefore my hands are tied. I'll go by the rule book. The Black and White Act says that consent is, the right to consent is not available to a minor. So where is the question of any controversy or confusion? So this judgment which came in recently, November 2022, it says, I'll go by that, so minor does not have a right to consent. It has referred to few judgments, otherwise we are having judgments, I am referring to. It's like you can have a list of 100 judgments on this issue right now, the way all high courts are speaking on this subject. We might have to create a book for this subject wise possibly, but I have just taken out few of them. So Delhi High Court in October 22, while dealing with a POCSO case, but bail issue came to court, it says, in my opinion, the intention of POCSO was to protect children below the age of 18 years from sexual exploitation. It was never meant to criminalize consensual romantic relationship between young adults. Now, this young adults, we have seen so many acts by now, we didn't get that. So, we have not seen the definition of young adults in all these acts, but the learned judge was referring to a term he possibly himself coined, young adults. However, this has to be seen from the facts and circumstances of each case. There might be cases where the survivor of the sexual offence may, under pressure or trauma, be forced to settle. The learned judge, then he grants bail, and he says this is a case where she consented to, because of whatever material was produced before the court. I'm just referring to a portion of the judgment where he says, A herself went to the applicant's house, asked him to marry her. The statement of the victim makes it clear that this is a romantic relationship between the two, and the sexual act involved between them was consensual. Although the victim is a minor and hence her consent does not have any legal bearing, I am of the opinion that factum of a consensual relationship born out of love should be of consideration while granting bail. To ignore the statement of the victim and let the accused suffer behind jail in the present case would otherwise amount to perversity of the justice. Now assume this was a case of trial. So the judge is agreeing this is, I cannot go by the consensual relationship concept because the act does not permit. But can't keep the accused behind bars. My question is this only, if you can't keep the person behind bars because trial has to go, but if this is the position of law, then at the time of conviction what you have to do? We have to send him behind bars unless the law is amended. So granting bail but convicting, are we reaching, towing that line? We are going there that we would not keep you behind bars for till trial, but yes, no option but to punish you and convict you and send you behind bars after conviction. Maybe this creates this confusion which we talk. This creates this confusion. The same judge in a month later only. I'm not naming judges. The same judge in a month later only. That was October. This is November. He says rejects the bail of the accused under POCSO by observing that consent of the minor at the age of 16 years, especially when the applicant was 23 years old and already married, also disentitles the applicant from grant of bail. Consent of a minor is no consent in the eyes of law. POCSO, same court, same judge, same situation, but here the bail denied. Another case where Allahabad High Court, again dealing with a bail only under POCSO, the age of the victim is just above 17 years, her date of birth being 10 so and so, thus the consent, if any, and I just love this expression, pales into insignificance. He denied bail by saying, sorry, I can't help, you are under 18, you are the victim, and therefore consent cannot be taken note of. Rajasthan High Court gone a step further. In a recent judgment, Rajasthan High Court actually quashed the FIR by taking note of the factual situation that they were into a love affair relationship, and therefore it would be wrong to try the person under POCSO Act. Though this matter is now under consideration, this particular issue is consideration before this honorable court, seized off and pending. I believe Vasan sir has been appointed amicus, and that would be argued before Justice Rastogi's bench. Bombay High Court, again in a recent judgment, granted bail to a 21 years old person. The girl was 15 years old. Observing that two were in relationship, she voluntarily accompanied the applicant. Same goes with then Calcutta High Court, Madhya Pradesh High Court in a Muslim personal law. He took note of, Madhya Pradesh High Court I'm referring, he took note of the case that the girl was Muslim. Muslim personal law permits minor Muslim girls to marry when they attain the age of puberty. Broadly they take it as 15 years. However, the parties herein were not married. The court denied to give any credence thus to the consent plea, by saying it is not a case of marriage, it is a case of POCSO. We'll go by that, and under the POCSO Act you are minor, then no consent. Alim Pasha is again one of the most talked about recently judgment of Karnataka High Court, where the Karnataka High Court, while taking cognizance of the age of puberty under the Muslim law, qua girls, and the permissible age of marriage, while dealing with all that aspect, though say POCSO is a special act and would having overriding effect over other acts, granted bail by observing that she was a consenting party. And then a recent judgment of Guwahati High Court, Calcutta High Court. Calcutta High Court said consent of the minor is immaterial. Guwahati High Court said it has to be relooked. And this is how the legal scenario. I'll just give you now the age of consent in various countries. That how, and this is a hot topic honestly internationally. We in 1890 had the age of consent as 10 years. And that's why our ancestors, predecessors, they had marriages at a very young age, and we had 9-10 children each family. We had these kind of things. But then it has increased from time to time. Then we had from the Majority Act, we had the age of 18 years. Just see internationally how it works, the age of consent. Only one national, in the country, one act remained to be told by me, and that is the Criminal Amendment Act 2013. There also the age of consent is 18 years only, because they again say minority and majority is after the attaining age of 18 years. Europe, they have ages of consent ranging from 12 to 21 years. Broadly, it is between 14 and 16. Broadly, by and large. I just name few countries like Iran, Qatar, Yemen, Afghanistan. They completely rule out a premarital sex or a sex without marriage. But several countries like Cyprus has age of consent as 17, Ireland has 17, Turkey 18, Iraq 18, Vietnam 18, Bahrain 21. They So many countries, in fact, I can put a chart to sir you, and you can place in the group. There is, each country, so many countries have an exemption of close in age. So if the parties are of close ages, then there is an exemption, because then there is a possibility of consensual relationship taking place. We still stuck up with the thing, can a minor exercise consent? But otherwise, in broadly countries, they have a concept of close in age exemptions, which is not like every single country has, but they have, which we do not have here. So maybe when all this debate is going on, one day we are also thinking of a close in age exemption. Now in like Australia's territory, be it all Northern Territories, Queensland, Victoria, Western Australia, the age of consent is 16 years. Southern Australia, they have 17 years age as the age of consent. The rest of the part has 18 years as age of consent. UK has 16 years as age of consent. Close in relationship is again, close in age exemptions are still available to them. So this is how the broad scenario around is. Now I'll just sum up with my take on it. So if a minor does not legally have a right to guard himself, herself, or maybe not understood as capable of having the capacity to guard himself or herself, his property, his person, be able to take a wise decision about his or her welfare. You had to have a guardian appointed. You need to look for you to be maintained. And then also, are your body grown up enough for the purpose of, when you see medically that aspect, to bear, if see a sexual relationship for a woman, then she might actually bearing a baby then. Are your abortion laws permitting abortion before the age of 18? And top of it, if you are assigning criminality to an act under an act, to certain acts, act is the activities, then how come by way of a judgments we just ignore that mandate of the act and say, no, I think because this seems to be consensual or a loving relationship, or they are into a romantic relationship, I as a judge would allow. So I personally would say, this is my take subject to correction, that we cannot actually discuss consent if the victim is under the age of 18. If we are giving all sorts of protection to a juvenile under Juvenile Act, because the person is under the age of 18, that innocence which we are assigning to a criminal act under the Juvenile Act, why shouldn't you allow the innocence of consent also to the person, so to say she was not capable of giving a consent, even if it is a consensual act? And therefore, in place of bringing down it or letting the accused go on the argument of consent, why not have an awareness created amongst the students? Our major concern is those students studying in college or schools. Create an awareness that you might enter into any relationship, but please be aware this is a legal position. So you can be conscious of a legal position and have whatever relationship and whatever restrictions or limitations or maybe reference you have to impose on. This is my take, maybe subject to correction. Thank you so much for bearing me, and I'm waiting for that discourse and debate and enlightenment from that side.
Thank you, Shobha. Very nicely explained dichotomy, POCSO and personal laws. Wonderful.
Thank you, sir.
Whatever laws available in the soil, so all explained, who is major, who is minor, excellently. And internationally also, different countries, what is the age and all.
Thank you, sir.
One of the best lecture we can say. One is a guiding, inspiring, and we can day to day several people
I
approach
hope
us
I
at
am
this
being
thing,
able
and
to just
yeah.
be at par of the standards of this forum.
So nice of you. Be claps and all. Any questions? Please raise please. Any questions?
Ma'am, in 1890,
India says consent age is 15. 15 time ago, consent and marriage age is different.
1890 it was 10.
1890. It's a
Maybe 4 or 5 years ago, maybe consent age is 15. marriage is 18.
No, no, no.
Indian.
That's Muslim law is 15, but otherwise.
Indian.
So I just refer to all.
I can show you.
Okay,
Right?
sure.
I know. I preparing law examination.
No, if you have anything, you bring that act provision, please. Not to.
Yeah, I prepared.
Just for your information, no. You bring that law, then you can contradict, please. I mean,
After that,
otherwise it's not. I mean, okay, it's all. Any more questions? Yeah, you are saying some questions.
Same question, sir.
Same question.
Same
Okay.
question, sir.
Any more? Yeah, please.
Ma'am, if we see the objective of the Act, the statement of objective, it says that it is to prevent inducement, exploitation, coercion. It uses these three terms. So when the fact suggests that there is a consent, all these objectives are coming into conflict with the fact. So can the court not take into consideration the objective of the Act and the provisions and try to fill in the gap of the statute?
So that's my point is actually, is there a gap? So normally court's role come into play when there is a void, there is a possibility of reading down, reading up, or filling the gaps. But if the provisions are mandatory, see what you have asked, if we see it from the glasses of section 29 and 30 presumption also. So it very clearly says you cannot enter into a sexual relationship with a minor. So with this, either you read down it without reading it down. My issue is that the provisions are challenged and the court read it down. A court say no, it can be read this way, without actually entering into that exercise. Just making observations, so to say, no, I think in my opinion this seems to be like this. And these observations are coming in what? In bail orders. If you see broadly all these orders, these are interim orders. But observations are coming in forth. So even they are not in a position to, because there are no evidence right now. Parties have yet to let evidence. And if the legal position is clear that minor cannot give consent, then how come you give benefit of that consent to an accused which is not legally available? That's my whole problem. My issue is this: if something not legally permissible, how come you give benefit of that to the accused?
Okay. Yeah.
The last point you had, can we bring it like a training or awareness? Because what I see, we go to the courts, that is something very legal. We are talking about children, 15 age, 16 age, 18 age. I went to a school also for training program, and I see that the moment you start talking to girls and these kids, they become a little shy, they don't want to talk to you. And the question comes, how will bring this thing to society? Because finally awareness is more important. If you talk about the act, this act should be teach to each and everyone, so that the results of that act, what is happening today in society, they can come down.
You're very right. Actually, there are so many acts. In fact, DVA, you talk DVA. There are so many acts which are not in the knowledge of the common man.
It
should be a chapter, and according to me, this POCSO Act should be a whole of chapter. Whatever, they must be having different sessions.
I want to add. Then second thing, you talk about the UN conventions, we are party to be ratified. Commonly people, they don't know, if judges know, they are not even confirmed about
Question.
So, how do we make it a point that yes, we are saying in UN, and when we talk about making a legislation, there is no voice. So these things has to be taken into consideration.
Especially POCSO should be taught in schools.
Through training
Should
and
be
awareness.
precisely that this is a legal position. No enter into whatever relationship you want to enter into. Because courts are also not coming to help for the accused who are not school students, or maybe our age bracket is.
Practically we are doing in society, we are the lawyers and we see on and off, nobody is going to come and support you. Until unless there is will of the advocate. Not even the police machinery. They'll make you write anything. The parents, they are coming from that. So this is something, I think what my suggestion was.
Legal awareness.
Awareness is important.
Yeah. You want one more? Yeah. Last question.
Precisely.
Thank you, Sharma.
I'm not asking the question, but I want to give the advice just like.
No advice, only questions, sir.
Ma'am,
We
the
will
warning,
give a lecture for you. Advice for that you will give a. Chalo, anyway, only 1 second. One second. One. Just you. Yeah.
Just curious to know, what is the position if both the parties are minor, below 18, say 17 and 18? What will be the position if the male is below 18 and female is above 18? And what is the position if the female is below 18 and the male is just 10, 18?
So if female is above 18, POCSO ruled out.
Ruled out.
One question answered. If so, victim has to be under 18. Okay.
No, so you are saying if the
POCSO is meant for both male and female. The victim can be either of the gender,
right,
right?
right.
But the victim has to be above the age of 18. Below the age of 18. The moment the victim is above the age of 18, POCSO ruled out.
So my
Then you comes to Juvenile Justice Act. Your
POCSO
victim
only
is
for female.
POCSO is not gender specific. But I'm saying a victim, the moment victim is above the age of 18, POCSO ruled out.
No, so what?
POCSO is not.
My question, I think I am not able to make you understand. I asked you, reverse the gender in two cases. In one case, the male is below 18, the other person is above 18. And
I'll
just-
reply it now. So POCSO is not gender centric. It's gender neutral when it comes to victim. Therefore, the moment victim is above the age of 18, POCSO ruled out.
So that.
Hold on. Now, if your victim is under the age of 18, but male or female covered by POCSO Act, then you would have to see whether the accused is below the age of 18 or above. Your accused can be of any age.
Yes.
So
My
if-
question is very specific to the age.
That's what
If-
I'm saying.
If the victim can be any person, male or female, right? So if the victim is below, let's take that's the reason I gave you the case. If a male
Female,
victim,
okay.
if a male victim is below 18 and female is above 18, and another stance, if the female is below 18 and male is above 18. So in both the cases, what is going to be the
I'll again answer the same way. So you have segregated by saying male, female.
Right.
I am taking them as victim.
Right.
This victim includes male, female, both.
Both.
If the victim is under the age of 18, she or he has to be given justice under the POCSO Act. It is to give justice to the victim.
Right. So what?
For punishment under, if the accused is above the age of 18, accuse either gender. You have IPC? If your accused is under the age of 18, then you have Juvenile Justice Act. When you are looking at POCSO, you are looking at POCSO qua a victim under the age of 18 of any gender. POCSO punishes.
So in one question, one of the first questions was both of them.
Yeah, we'll do one thing. We'll extend it everything in a canteen. Please. We have to see others' patients also. Rahul will give vote of thanks finally. We'll join the canteen
Ma'am,
for
we are
the
really
doubts.
thankful to enlighten us, to all the Friday group members, and you have taken us to all the laws regarding civil, criminal, POCSO, and all the cases regarding the age, to find out the age, what is the age of minority and majority. And there's a bit confusion with regarding the case laws also and the bail applications that you have told from the high courts that they have granted bail, but in the conviction part, if they can, they have to convict them ultimately. So we are really thankful to ma'am.
Thank you so
Really
much. Pleasure is mine.
Autograph. Next page, any message here, your autograph. Next page, any message.